Swayam Prabha. Digital India. Educated India.
Well, students, this is Dr. Ajay Kumar Singh, Assistant Professor, Faculty of Law, BHU. So, this is my 6th lecture, and today I am going to discuss violence against women, a big challenge to human rights. So, in this lecture I would like to highlight those areas where those important case laws through which I would like to highlight what are the causes for violence, and violence against women are considered as a big threat for protection of human rights. So, first of all, you all need to understand that what are those fundamental rights, what are those human rights which women can get as matter of right. What are those human rights which women are entitled to get? So, as you all might be aware about UDHR, Universal Declaration of Human Rights 1948, which talks about right to equality. Article 1. Article 1 says that every person, every human being are born equal. Every human being on this universe is born equal. It means Article 1 of this UDHR makes it clear that every person is equal by birth. Article 3 of this UDHR talks about right to life. Women are also entitled to live with all human dignity. Right to life, women have fundamental right, women have this kind of precious right, they are entitled to live with human dignity according to Article 3 of Universal Declaration on Human Rights. They are equal in eye of law, they are entitled to get equal pay for equal work. Article 3 right to life. They are also entitled to get fair wages, they are also entitled to get right to education. You all might be knowing that right to education is a fundamental right, right to education is human right, right to marry of his choice or her choice, that is also human right. Every person, be it male or female, has his or her choice to marry with his own choice, her own choice, right to marry, right to education, right to food, right to shelter. These are certain rights which have been recognized as human rights. So, women are also entitled to avail these rights. Since my topic is violence against women, and I will try to confine myself towards this topic, that what are those rights which are violated by state agencies or by individual, by the respondent, and what is the role of criminal justice system, how criminal justice system has been effective to protect rights of women in this country. Particularly I will try to explain statutory provisions and constitutional provisions which have been specifically designed for, enacted for the betterment of Indian women. So, as you all might be aware, you just see this violence against women. I have mentioned this word violence against women, a big challenge to human rights. So, the word violence includes physical, mental violence, emotional violence, forms of violence. Violence appears into different forms. Generally, when we hear this use violence, violence means something wrong which might have been committed against another person by one to another. So, violence always hits the mind of a common man that something wrong has been committed by one person against another person. But in the same meaning, violence, though violence word has not been defined in particular, domestic violence word has been defined in Domestic Violence Act 2005, but either in form of dowry death, you might be aware about this dowry death, murder, honor killing, where female or whether girls are killed due to just to respect honor of a family, honor killing, sexual abuse. These are different forms of violence which frequently occurs against women, and we will try to understand what are the laws on these issues, how laws have been effective to tackle this menace, to tackle these problems. And victim of crime, once their rights are violated, once they become victim of crime, being victim of crime, what rights they can claim against the state, what are the rights of victim of crime. I would also like to highlight the rights of victim of a crime. So, where rights are violated and once a female becomes victim of crime, she has certain rights under criminal justice system. What rights are available to a victim of crime, a female, a woman who is victim of crime? A woman who is victim of crime, who has been assaulted or any kind of mishappening takes place against her. So, a female being a victim of crime has right, the first precious right in the hands of victim of crime is right to lodge FIR or right to file a complaint against the respondent. So, right to file a complaint or right to lodge FIR against the culprit, this is the most precious right in the hands of victim of crime. A female who has been assaulted by her husband or by her relatives of husband, then she can either give information to the police under section 154 CRPC. Police may lodge FIR, police may record her statement, FIR shall be lodged, and police may arrest her husband or any relatives of the husband if any kind of cruelty or violence has been committed by her husband or relatives of the husband against women. So, after lodging FIR, she can put police into motion, and she has two options, either she can lodge FIR under section 154 CRPC or she can file a complaint before the magistrate by stating entire facts before the magistrate that such kind of violence has taken place and such kind of cruelty has been committed against these women. So, she can make complaint. This is the first remedy which is available to a victim of crime. Second important right which a female can claim, that is right to be impleaded in the proceeding, in criminal proceeding. Suppose where a female, a married woman who has lodged FIR against her husband, now trial begins, court is willing to grant bail to the respondent. So, as per the committee, as per Malimath committee recommendation, that Committee on Criminal Law Reform 2003 makes a very good recommendation that before grant of bail, the victim of crime must be given opportunity of hearing. Without giving opportunity of hearing to victim of a crime, bail shall not be granted to the accused. Reason behind giving this kind of opportunity to a female would boost up her confidence in justice delivery system, that she has been, at least she has been given opportunity of hearing by the court and to raise her objection if court is willing to grant bail to the accused. So, you see, before grant of bail, if victim of crime is given opportunity of hearing, if she makes objection that if accused shall be released on bail, he might create some problem to the victim, or he can create some great problem. He may be the release of that offender may create problem for that victim of crime. If there is sufficient evidence, then court will not grant, court may refuse to grant bail to the accused. So, this kind of right is also available to a victim of crime. Another important right in the hands of victim of crime is right to be impleaded in criminal proceeding. Victim of crime must be impleaded in criminal proceeding if where application is made by victim of crime to the court that she must be made a party to the criminal proceeding. She must be impleaded in the criminal proceeding. The reason behind making this kind of provision is that once a victim of crime is impleaded in the criminal proceeding, he or she can give valuable suggestion to the court, or he may can give important evidence before the court, which police officer, investigating officer has not knowingly or unknowingly has not brought before the court. So, this is another important aspect for giving liberty to the victim of crime. The next important right which a female can use against the offender, against the respondent, is right to file protest petition. Protest petition is another important means in the hands of victim of crime. As you all might be aware about two important case laws. With the help of case laws, you can understand that how a victim of crime can use this technique, this right, effective means, right to file protest petition. You know, protest petition is filed in that very court where final closure report is submitted by the police by saying that there was no sufficient evidence against the accused. So, matter should be closed. If this kind of statement is known as closure report, and the provision regarding closure report is given in section 169 CRPC. So, once closure report is submitted to the before the court and victim of crime is not satisfied, she can file protest petition in that very court where closure report has been submitted. Amarmani Tripathi case is very good case on this. Madhumita Shukla murder case is very leading case on this point. In Amarmani Tripathi case, closure report was filed by UP police because accused was influential person, accused was minister, accused was MLA at that time. Being MLA or influential person, police officers they had submitted closure report by saying that, by stating entire facts in that closure report, that neither Amarmani Tripathi nor his wife were involved in that murder, Madhumita Shukla murder case. So, closure report was filed by the UP Uttar Pradesh police by stating that matter should be closed against Amarmani Tripathi and his wife because both were not involved in that murder. But now you see how protest petition was filed by victim of crime by sister Nidhi Shukla. Nidhi Shukla, she is younger sister of the deceased Madhumita Shukla. So, Nidhi Shukla filed a protest petition in that very court where a closure report was filed by the police, Uttar Pradesh police. She stated before the court that she was not satisfied with that investigation which was conducted by Uttar Pradesh police. So, she has no faith in UP police. So, matter should be transferred to the CBI. Are you getting my point? You will be surprised to know when you will go through the facts of this case. When matter was referred to the CBI, CBI filed a charge sheet in that case. Here you can see the efficacy of protest petition, how protest petition can become important means in the hands of victim of crime. Deceased sister filed a protest petition in the court that she was not satisfied with the closure report. When matter was reinvestigated, High Court gave direction that matter should be referred to the CBI. When CBI interrogated the matter, CBI filed a charge sheet against Amarmani and his wife. Both were found culprit because DNA report was there, sufficient evidence was there. So, on that basis matter was transferred from Uttar Pradesh to Uttarakhand, and on the basis of that protest petition they were convicted by the trial court, and High Court also confirmed their sentence. So, you see how in the same case investigating agency was UP Police, then UP Police submitted closure report. When investigating agency was changed by judicial intervention, CBI matter was referred to CBI, CBI filed charge sheet in the case. So, can you see the efficacy of protest petition? So, protest petition is also very important right in the hands of victim of crime. Another important right in the hands of victim of crime, that is a right to appeal, where you see where accused is acquitted by the court, offender is acquitted by the court. In case of acquittal, generally state has to make an appeal, prosecution has to go in appeal, but where state or prosecution is not making an appeal against acquittal order, then in that case what would happen to that family who has lost its male member of that family or who has lost his female member. So, if any victim who has lost his loved one, his any member of his family, and offender is acquitted, appeal is not made, state is not making appeal against that acquittal order, then what would be the remedy if victim of crime is not satisfied? So, you see now section 372 of the CRPC has been amended, and in that section it is specifically provided that victim of crime can also make an appeal in case of acquittal, or where in case of inadequate sentence, where sentence is inadequate, lesser sentence has been passed by the court, then victim of crime may also go in appeal, and by saying that trial court has not awarded severe punishment, sentence is inadequate. So, this sentence should be enhanced. So, either for the enhancement of the sentence or for the conviction that accused has been acquitted by the trial court. So, this accused must be convicted. So, in these two situations victim of crime can make an appeal against acquittal order, or where accused is acquitted on the ground of inadequate sentence. These are certain rights which victim of crime can avail. So, I think that you all must have understood that what are important rights which victim of crime can avail. Victim of crime here means I am talking about violence against women. Who is victim? Section 2 WA of the CRPC defines who is victim. Section 2 WA, as you might be knowing that section 2 WA has been inserted in the year of 2009. So, you need to remember that provision. Now, come to look at your screen. I have highlighted this violence. The first significant thing which I have covered, that is dowry death. You might be aware about dowry death. In most of the cases which are brought into the notice of the court, that these cases are related to dowry death. Dowry death as per NCRB report, I have also highlighted NCRB report. You see NCRB report reveals that in the year of 2002, dowry death related cases were reported as 6,450 cases were reported on dowry death. NCRB reveals that, second point, 13,479 cases have been reported under Dowry Prevention Act 1961 in the year of 2022. So, Dowry Prevention Act 1961, which was enacted by the parliament to prohibit the dowry, giving dowry and taking dowry both have been made punishable. So, in the year of 2022, 13,479 cases were reported under this Dowry Prevention Act 1961. Another important case on this point is, you see, this is government statistics, NCRB National Crime Record Bureau report 2022. I have, you see, I have referred this data, NCRB data, so that you can understand the ground reality of violence against women, and the same case is with dowry death or cruelty. You will be surprised to know that in a particular year, in the year of 2012, there were 1,97,600 something, 1,97,600 cases were reported only in one section, and it was section 498A, cruelty. So, in the year of 2012, the most significant provision of the Indian Penal Code was section 498A, cruelty. In that section, 1,97,647 cases were registered, FIR were registered, means 1,97,000 FIR were registered only in one section. So, you can see the ground reality of NCRB report. I am referring NCRB report. I would like to highlight two important case laws. You see, you look at your screen, Lakshma Devi, this is Lakshma Devi versus Union of India, and Sarad Virdi Chand Sarda versus State of Maharashtra. With the help of these two judicial pronouncement, I would like to draw your attention. In Lakshma Devi versus Union of India, you see what happened. In this case, the appellant was prosecuted for committing dowry death of her daughter-in-law. You see, it was the year 1986 when dowry death, section 304B, 304B, which talks about dowry death, was inserted in the Indian Penal Code just to criminalize dowry death. And in soon after 2 years, in 1988, a case came before the Supreme Court for its consideration. In Lakshma Devi case, what actually happened, Lakshma Devi, she was prosecuted for committing dowry death of her dowry for her daughter-in-law. The facts of this case are, the deceased before her death made a statement to the police that after pouring kerosene oil on her body, her mother-in-law and husband, they ran away from their home. When she was crying, then neighbors came there, and with the help of neighbors she was hospitalized, and in the hospital, during when statement was recorded, she made same statement to the police, to the doctor, that her mother-in-law and they were involved in that incident. After some days she died. So, that her statement, that the statement of deceased was considered as dying declaration. You all might be knowing that dying declaration is very important substantive piece of evidence under section 32 of the Indian Evidence Act. Section 32 of the Indian Evidence Act says that where statement is made by deceased before his death or her death about the cause of death or the circumstances under which death was caused, that statement is considered as dying declaration. So, on the basis of that statement, Lakshma Devi was prosecuted and convicted. When trial court convicted her, and trial court considered that case as an arrest of rear, and trial court convicted her. When matter was, when she went in appeal, High Court also confirmed, upheld judgment of trial court. When she went in appeal before the Supreme Court, one important plea which was taken before Supreme Court against Lakshma Devi, that she should be publicly hanged. She Lakshma Devi, being a mother-in-law, she committed very brutal act. She was involved in that dowry death. Dowry death was proved. So, she should be hanged publicly, so that lesson can be taught to the society and no person will dare to repeat such kind of incident in future. So, exemplary punishment should be awarded to this lady, to this female. This kind of plea was taken, but Supreme Court rejected that plea, and Supreme Court. So, you see this case is also important in that head, where public hanging was first time demanded in this case, that this female should be hanged publicly, so that a lesson can be given to the society. Another important case which you can see on your screen, that Sharad Birdi Chand Sarda vs. State of Maharashtra. I have referred this case deliberately in this head, violence against women. You see, Sharad Birdi Chand Sarda, he was prosecuted for committing murder. You see what happened in case, deceased before her death had written several letters to her father and sisters, by saying that husband and her mother-in-law both, they used to demand dowry, and it was written in that letter was written to by deceased to her father and sister. So, and when deceased died in mysterious circumstances, the letter which she had written before her death to her father or sister, the content of that letter was considered as dying declaration under section 32 of the Indian Evidence Act, and the offenders were punished. Dowry death related cases. Now come to another aspect of violence against women, sexual offences against women. Sexual offences are another important or significant area where we all can see that violence against women takes place. Mathura rape case is very sensational case on this point. I have already highlighted in my previous lecture. In Tukaram vs. State of Maharashtra, it was a case of custodial rape, but Supreme Court did not act, though trial court and high court both have convicted the offender under section 376 of the Indian Penal Code, but when they went in appeal before the Supreme Court did not accept the plea of government, and Supreme Court acquitted both the offender Tukaram and his friend from the charges of rape under section 376. Rupan Deol Bajaj versus KPS Gill. You might be aware both were senior IS officer. Rupan Deol Bajaj, she was an IS officer, and KPS Gill, he was DGP, Director General of Police of Punjab. So, allegation against KPS Gill was that he molested Rupan Deol Bajaj at the time of party, during party season. So, she filed a complaint against DGP, that DGP KPS Gill, he actually committed offence against Rupan Deol Bajaj. Under section 354 complaint was filed. Section 354 IPC makes an act punishable, that is outraging modesty of women. Outraging modesty of women is an offence under section 354. So, you see this is a case on another important case which I have covered, that is Nirbhaya incident. You may have some idea about this incident. A gang rape of a girl in December 2012 took place in Delhi, national capital Delhi. In that case, a girl who was pursuing his graduation, she was raped by few offenders in December 2012. In this case, what actually happened, and during that incident she died. This case was tried by fast track court, and fast track court found all the offenders guilty under section 376 of the Indian Penal Code. Considering the gravity of this issue, matter was referred to the fast track court, and fast track court finally convicted all the offenders who were involved in that case. all the offenders were convicted under section 376 for committing rape of that girl. So, the matter was appealed in Supreme Court, and Supreme Court finally confirmed the punishment awarded by trial court and upheld by the High Court. Supreme Court also considered this case as a rarest of rare case. The doctrine of rarest of rare case, as I have already highlighted in my previous lecture, the doctrine of rarest of rare case was evolved by Supreme Court in Bachchan Singh versus State of Punjab AIR 1980 Supreme Court. So, considering this Nirbhaya incident as a rarest of rare case, Supreme Court convicted all the offenders under section 376 committing rape and with murder 302 of the Indian Penal Code. And then after a Burma committee, Justice Burma, under the chairmanship of Justice Burma, a committee was set up by the Government of India to give valuable suggestion on criminal law reform. So, Justice Burma committee has made several important recommendation on this point, which I would like to refer in my next slide. Here you see sexual offence against women at working place. This slide will make it clear that where sexual offences are committed against women at working place, what are the procedures to tackle that problem, to handle that situation. You might be aware Vishakha versus State of Rajasthan. Vishakha versus State of Rajasthan AIR 1997. In this case Bhauri Devi, this case is also known as Bhauri Devi gang rape case, and guidelines issued by Supreme Court in this case, I would like to quickly highlight, explain the facts of this case, what actually happened. Bhauri Devi, she had been involved in raising voice against child marriage in Rajasthan, and she was raped by local resident. So, the matter was raised by Vishakha in the court of law. When matter was brought into the notice of Supreme Court issued guidelines directing the central government as well as state governments that all the state governments, union territories have to ensure that the first thing is that establishment of, you just can see on this slide, establishment of WGC in government as well as in private establishment. It is, you see, every government institution or private institution will have WGC, Women Grievance Cell, so that complaint regarding this can be expeditiously disposed of. Respondent can be prohibited to enter into the premises where victim is working. So, this thing can also be, it is the duty of employer to prohibit respondent not to enter in that premises where victim of crime is working. And you see the guidelines issued by Supreme Court in this case or guidelines issued by Supreme Court in any case are as good as law passed by the legislature, passed by the parliament. So, these guidelines are as important as law enacted by the parliament, but Supreme Court said that unless these guidelines are legislated by the parliament, these guidelines shall be treated as law for this country. Now, parliament has enacted special legislation, the Protection of Women from Sexual Offence at Working Place Act 2013. The special legislation has been enacted by the parliament. Now, you look at your screen on this slide. I have made this slide so that PIL can also be covered. PIL as an effective means for prevention of violence against women. How with the help of PIL violence against women can be prevented? To what extent PIL, public interest litigation, has played important role in prevention of violence against women? I would highlight two important judicial pronouncements, and with the help of these two judicial pronouncements, I would like to explain the guidelines issued by the Supreme Court. This first case is Delhi Domestic Working Women Forum versus Union of India AIR 1995 Supreme Court. Delhi Domestic Working Women Forum versus Union of India, AIR 1994. This is an NGO, Delhi Domestic Working Women Forum, that is registered society, non-governmental organization NGO, and this NGO has been working for women cause, for the welfare of women. So, what actually happened in this case? In this case, 4 domestic women workers who were travelling from Ranchi to Delhi in a train. So, when they were travelling from Ranchi to Delhi, railway officers, railway employees, they committed a rape in train against 4 domestic women workers. When they reached Delhi, they stated entire facts to this Delhi Domestic Working Women Forum. When matter was brought into the notice of this NGO, which has been working for the betterment of women welfare, matter was brought into the notice of High Court. You see, in this case, when matter was brought into notice of Supreme Court, 3 judges of Supreme Court issued important guidelines for the protection of women's right. So, 3 judges of the Supreme Court issued guidelines against the government, against the railway administration. The first guideline which I would like to refer, the first important guideline issued by Supreme Court in this case is legal aid at railway station. List of counsel must be displayed at railway station. Name of the rape victim must not be disclosed. So, Supreme Court issued guideline that railway department must ensure that in each and every railway station the list of counsel, list of advocate must be displayed. In case of emergency, in case of legal assistance, the counsel, advocate may be contacted, their contact number must be displayed, and railway authorities are under obligation to provide legal assistance at each and every railway station. You see, this is the first important. It is also Supreme Court further warned the state railway administration that every railway station must have railway protection force, and it is the duty of railway administration to deploy railway protection force in every train, so that this kind of mishappening could not be repeated in future. So, you see this how this matter was taken up by Supreme Court, and Supreme Court was very much concerned about this kind of thing, and direction was issued. Second important case on this point, which you can see on your screen, that is Chairman Railway Board versus Chandrima Das. Another important case, Chairman Railway Board versus Chandrima Das, AIR 2000 Supreme Court. So, I would like to explain the facts of this case, what actually happened in this case. You see, in this case, PIL under section 226 was filed, public interest litigation was filed before Calcutta High Court, and in this case Chandrima Das, being a social activist, having interest in social cause, had filed a public interest litigation under article 226 before Calcutta High Court by stating entire facts which happened against Srimati Hanifa Khatun, a Bangladeshi citizen. Hanifa Khatun, when she wanted to get a train at Howrah railway station, Hanifa Khatun, being a Bangladeshi citizen, she was not aware about the thing. She inquired some information from railway employees. So, railway employees, they took her at a place and they committed rape against Hanifa Khatun, since she was foreigner. When matter was brought into the notice of Chandrima Das, she decided to fight her case, and a PIL was filed in Calcutta High Court. Calcutta High Court passed order against Railway Department by saying that Railway Department has failed to protect the rights of a foreigner, even a citizen of foreign country, a person who is a foreigner is also entitled to live with human dignity. Article 21 is also available to a foreigner. Foreigner is also entitled to live with all human dignity. So, a plea which was taken by Railway Department, Chairman Railway Board was party in this case, and Railway Department took plea before the court that she was a Bangladeshi citizen, she belongs to Bangladesh. So, government Railway Department is not bound to pay compensation to that lady, but this plea was not accepted by Calcutta High Court. Calcutta High Court held that it is the negligence of Railway Department, and that is why concerned Railway Department is under obligation to provide compensation to this victim. So, in this case Chairman Railway Board went in appeal, matter was appealed to the Supreme Court. Finally, Supreme Court upheld the decision of Calcutta High Court by saying that Calcutta High Court was right in upholding the right to life and dignity of a foreigner in this case, and Supreme Court held that this victim must be provided 10 lakh rupees as a compensation. In this case 10 lakh rupees was given as a compensation. So, and Railway Authority had to provide 10 lakh rupees as a compensation to the victim of crime. This is another important case which you need to remember. Now, come to this another important slide which I have already prepared for your knowledge. You see, I have covered constitutional protections. What are those constitutional protections available to women? You all are aware, Article 14, right to equality. State shall not deny right to equality or equal protection of law within state, means they are equal in eye of law. Article 15 is special legislation for women. What is Article 15? It is specifically mentioned under Article 15 clause 3 that nothing in this article shall prevent the state from making any special provision for children and women. It meaning thereby state can make special legislation for the betterment of children or women. So, for that purpose Indian Parliament enacted the National Commission for Women Act 1990. You just look at your screen. Special legislation for women, the National Commission for Women Act 1990. This National Commission for Women Act talks about there shall be a National Commission for Women at central level and State Commission for Women. These two important commissions are working especially for the betterment of Indian women. So, you can see the seriousness of Indian Parliament. Indian Parliament took it seriously that women should be given more preference, and there should be separate commission for redressal of their grievances. Article 16, you all might be doing that, right. Article 16 talks about right to equality in public employment. State shall not deny to any person in right to equality in public employment merely on the basis of race, caste, sex, religion. Irrespective of caste, sex, religion, every person has right to get equal opportunity in public employment, that is fundamental right. Under Article 16, women are also entitled to get equal opportunity in public employment. State shall not make any kind of discrimination on the basis of sex, caste, religion and so. female is one sex. Article 16. Article 21, which talks about right to life. You just can imagine, without this right to life, all the rights are meaningless, all the rights would be meaningless. So, women are also entitled to live with human dignity. Right to life, Article 21 gives liberty to Indian women to live with human dignity. These are constitutional provisions where women have got freedom, women have also been covered under constitutional scheme, and they have been put on more, they have been given more preference under Article 15. So, these are few constitutional provisions where women have got more liberty. Now, come to statutory protections. Now, we will try to understand what are the statutes enacted by the parliament for the betterment of women. What are those statutes which have been enacted by parliament or state legislature for the prevention of violence against women. We will try to understand with the help of this slide. Now, you see I have covered, you may see this statutory protection to Indian women. Statutory, what are statutes? Statutory protection. The first important statute is sexual harassment of women at workplace. Sexual harassment of women in bracket at workplace, in bracket you can write prevention, in bracket prevention, prohibition and redressal Act 2013. As I have already emphasized that this act was enacted by parliament in conformity with guidelines issued by Supreme Court in Vishakha versus State of Rajasthan case. Supreme Court has already issued guidelines in Vishakha case, and Supreme Court has also requested to the parliament that parliament should make special legislation on this matter, and considering the gravity of that matter, parliament enacted this special legislation in the light of that judicial pronouncement. So, I will try to explain the important guidelines of this case. In this act, the word sexual harassment word has been defined. This act has also prescribed that compensation must be awarded in case of rape, in case of sexual assault, sexual harassment. Nari Shakti Puruskar should also be promoted. Actually, you see, Burma committee has also made several recommendations to prevent such kind of incident, harassment, sexual. Now, come to another important legislation. You can see on your screen, you see protection of women from domestic violence. Protection of Women from Domestic Violence Act 2005. This act is a milestone in achieving the object, in achieving the liberty of women. This act was enacted by parliament in the year of 2000, Protection of Women from Domestic Violence Act 2005. Another important legislation is the Equal Remuneration Act 1976. This act was enacted by parliament in 1976, Equal Remuneration Act 1976. According to this statute, every person is entitled to get equal pay for equal work. So, women are also entitled to get equal pay for equal work. Statute is very clear. So, women are entitled to get equal pay for equal work. IPC Indian Penal Code 1860, you just look at this IPC 1860. I have covered only 3 important provisions: dowry death section 304B, section 302 murder, and section 498A cruelty. So, cruelty dowry death, section 304B, and section 498A, which defines cruelty. Cruelty is a more serious crime, and the nature of cruelty, in order to make this cruelty more effective, more stringent, more tough law, the nature of cruelty is cognizable and non-bailable. This offence has been made cognizable and non-bailable in first schedule. Once the application is made by a victim, by a wife, by women against her husband, that husband and his relatives, husband's relatives, they have committed cruelty against physical cruelty or mental cruelty. The moment she makes application against her husband or against her husband's relatives, that statute gives liberty to the police to arrest husband as well as relatives of the husband. If husband or relatives of the husbands are nominated in FIR, so you can see the efficacy of cruelty, so that a male cannot commit crime against female, a husband cannot commit cruelty against his wife. So, if application complaint regarding cruelty is given, then in that case police would be at liberty to arrest husband or relatives of the husband. So, now this is the another important feature here. Dowry Prevention Act 1961, this act was enacted. Dowry Prohibition Act 1961. So, in order to prohibit dowry, this statute was enacted in 1961. IPC, miscarriage, assault, means there are several specific offences in Indian Penal Code wherein husband or relatives of the husband have been covered. So, miscarriage, forceful miscarriage, assault, if where wife is assaulted by her husband, even that would be an offence under in Indian Penal Code. We are also having National Commission for Women, State Commission for Women, and these important commissions are working for women cause, and these commission have been empowered by the statute to redress the grievances of Indian women. So, I think I have covered each and every aspect of violence against women. That is a big problem, and you see this violence against women has been identified as a human rights problem. So, there are three important human rights problems which have been seen, which we can see that the first is violence against women, second is violence against children, and third is police atrocities. These three are major problems which our Indian criminal justice system is facing: violence against women, violence against children, and police atrocities. So, Indian criminal justice system, though the Indian criminal justice system is very effective, has been effective in providing justice to the victim of crime, but how we can say that Indian criminal justice system has been very effective in providing justice to the victim of crime, or Indian criminal justice system has been effective in protecting human rights of women, human rights of children, or have been effective, Indian criminal justice system have been effective in preventing police atrocities. So, with the help of judicial pronouncement, with the help of judicial decisions of the Supreme Court, we can justify our argument that our Supreme Court, particularly our Supreme Court has been effective in protecting human rights of women, human rights of children, and prevention of police atrocities. So, I think I have covered each and every aspect of violence against women, and violence, protection of women from domestic violence. I would like to cover this major issue in my next slide, and I do believe that I have covered statutory protection, constitutional protections, role of Supreme Court in prevention of violence against women, and to what extent Supreme Court has been effective in preventing violence against women. We have seen, I also try to emphasize, focus on those judicial pronouncement through which you can get entire information that Supreme Court, how Supreme Court has been effective in prevention of violence against women. And we are having several legislations for prevention of violence against women. So, with this I would like to conclude my lecture, and assuming that you all have understood the things which I have discussed in this 1 hour session. If you all read all these informations, if you have all these information regarding statutory provision, constitutional provision and judicial pronouncement, I have no hesitation to say that you will get success in your coming examinations, where with the help of this judicial pronouncement, with the help of statutory provision, you can correct your wrong information, and you can also add something in your information. So, with this I would like to conclude this lecture. Thank you all.
Hello and welcome to this piece of literary snippet. We usually know William Shakespeare as the most revered figure in the history of English literature. But we often tend to forget that he has also been one of the most hated figures in literature. And here I am not talking only about those boys and girls who have to memorize long sections from Macbeth or King Lear or Julius Caesar before they can go and sit for their school or college exams. But I am also talking about people who are themselves quite famous authors. Tolstoy, for instance, considered the writings of Shakespeare to be, and I quote, crude, immoral, vulgar and senseless. George Bernard Shaw absolutely loathed Shakespeare, as he did Homer. But perhaps no other criticism about Shakespeare is more damaging than the one which says that Shakespeare is a marvelous storyteller, provided someone has told him the story earlier. Now, this piece of criticism is particularly damaging because it is true. None of Shakespeare's plays contain any original story whatsoever. They are all written using pre-existing materials, pre-existing stories. Now, does that diminish the stature of Shakespeare as a dramatist? Well, I'll leave that for you to decide. See you in the next episode of Literary Snippets.